5 seconds to go. Start. During recent years, the number of road accidents in the country have increased more alarmingly. Almost every day, one finds in the newspapers sad tales of road accidents. There is therefore an urgent need for streamlining the mechanism through which the victims or their legal representatives are compensated for their loss in such accidents so that they may be able to receive expeditiously an appropriate amount as compensation for the damages sustained by them. It is felt all round that victims of motor accidents and their legal representatives, where the accident is fatal, besides having grievously suffered as a result of the unfortunate event, are subjected to the agonies and uncertainties of a legal battle for a number of years for receiving the damages due to them through the process of court. Of late, Lok Adalats have been settling the cases of such nature, but it has been found that the victims or their legal representatives are compelled to be satisfied with a paltry sum out of the damages claimed by them. Such persons have no other option but to settle the dispute because they do not know for how many more years they will have to litigate for receiving the damages. In the backdrop of these and other related matters, the Law Commission has suo moto taken up the exercise of finding a solution to some of the problems relating to the Motor Vehicle Act and giving their appropriate recommendations thereon. The MV Act 1988 is fundamentally a social welfare legislation enacted with the objective of providing a mechanism for victims and their families to seek compensation for loss or injury resulting from road accidents. Additionally, its provisions regarding licensing and penalties for traffic violations serve the broader purpose of promoting road safety. Being a welfare legislation, it must be interpreted in a manner so as not to deprive the claimants of the benefit of the legislation. Any interpretation of its provisions must reflect the dual purpose of not only as a mechanism for ensuring timely compensation and relief for victims of road accidents but also in promoting overall road safety. The issue in this reference is whether an individual holding an LMV license can legally drive a transport vehicle if it falls within the stipulated weight limit of 7,500 kgs. The genesis of the issue stems from disputes regarding the payment of claims by insurance companies for accidents involving transport vehicles operated by individuals holding licenses to drive light motor vehicles. The question before this court is not one of statutory interpretation but also involves concerns of road safety and public welfare. In interpreting any statute, it is always prudent to keep an eye on the object and purpose of the statute as well as the underlying reason and the spirit behind it. However, we are conscious of not overstepping into the policy domain, which is essentially the prerogative of the legislature. The legislature is uniquely positioned to examine the broader social, economic, and safety considerations that underlie transportation policy, and any changes to the law must be rooted in comprehensive public discourse and analysis. Having noted the broader objective of the MV Act, let us now discuss the statutory scheme. It is a fundamental principle of statutory interpretation that construction is to be made of all the parts together and not of one part only by itself. When attempting to discern the meaning of a certain provision in a statute, it is essential to consider that provision within the broader context of the entire legislative framework. The context encompasses several other critical dimensions. First, it involves reading the statute as a whole, relying on the judgment in Prabhu Lal Supra, which distinguished Ashok Gangadhar Maratha Supra. The court in Angad Kol held that a driver of the mini goods carriage auto holding a LMV license need not have a license for a transport vehicle. The court also referred to Anappa Irappa Nisaria Supra to note that the amendment applicable prospectively specifically introduced the term transport vehicle in section 10. Following this amendment, a specific endorsement for driving a transport vehicle would be necessary. It was also noted that since the license was granted for 20 years, a presumption arose that it was for a vehicle other than a transport vehicle. It was ultimately held that the driver did not have a valid driving license for driving a goods vehicle, and breach of conditions of the insurance policy was found apparent on the face of record. However, exercising its power under Article 142, this court directed the insurance company to deposit the compensation amount before the tribunal with liberty to the claimants to withdraw the same, providing the right of recovery to the insurance company to recover the deposited sum from the owner and the driver of the vehicle. Before this court, the counsel for the insurance companies placed reliance on the above decision in Angad Kol Supra to argue that there is a clear distinction between transport vehicle and light motor vehicle. Let us examine if such argument deserves our endorsement. The decision in Angad Kol Supra was rendered when Prabhu Lal Supra and Anappa Irappa Nisaria Supra held the field. However, as we have noticed earlier, Prabhu Lal Supra conspicuously failed to notice the definition of LMV in section 221, even though it considered the definition of transport vehicle. It also wrongly distinguished Ashok Gangadhar Maratha Supra, where the legal position was clearly stated as under. The definition of light motor vehicle as given in clause 21 of section 2 of the Act can apply only to a light goods vehicle or a light transport vehicle. A light motor vehicle otherwise has to be covered by the definition of motor vehicle or vehicle as given in clause 28 of section 2 of the Act. A light motor vehicle cannot always mean a light goods carriage. Light motor vehicle can be a non-transport vehicle as well. The court in Angad Kol Supra overlooked the crucial legal analysis in para 9 and 10 and instead distinguished Ashok Gangadhar Maratha Supra by relying on para 11, where the court only provided additional reasoning on the requirement of a permit. A driving license is different from a permit. The conflation of the two terms led to the confusion. While a driving license relates to a driver's qualification, a permit relates to the vehicle's operational classification. The court in Angad Kol Supra also relied on Anappa Irappa Nisaria Supra, which held that the introduction of transport vehicles post amendment would imply that a specific endorsement would be needed for transport vehicles. At the cost of repetition, even otherwise, a comprehensive reading of the MV Act and rules shows that the specific mention of the term transport vehicle in different places of the Act and rules for the purpose of driving license would reasonably be applicable only for those transport vehicles that fall above the weight limit prescribed in section 221 for LMVs. In S. Iyappan versus United India Insurance Company Limited, the two-judge bench relied on inter alia Ashok Gangadhar Maratha Supra and Anappa Irappa Nisaria Supra. The case stemmed from an accident involving a Mahindra Maxi cab, a light motor vehicle that led to the death of one person. Stop.